This is Virtual Lawyer, and I'm going to be discussing key legal issues surrounding the FTX collapse and Sam Bankman-Fried. Not all facts are known as this debacle continues to unfold, but it is clear that SBF did in fact use customer funds from the centralized FTX exchange to cover losses in his failing crypto empire. As you are very well aware, I'm sure, if you're in the crypto space, you know that panic, fear, confusion, and most notably anger are emotions that are permeating and now deeply embedded in the crypto Twitter space, as well as in the public media surrounding this pretty catastrophic event. This is not just one of the biggest crimes or scandals in crypto, which it is, but it very well may go down as one of the biggest financial scandals in history. Reminiscent of the Bernie Madoff incident that some of you older folks might be aware of. So to be clear, before I continue on this video, we do not, I repeat, we do not 100% know what is going on right now with this case. There's a lot of speculation, there's a lot of rumors, conspiracy theories floating out there. So just to be transparent and remain transparent with you, because that's a goal of mine, we don't have irrefutable information about what is happening right now or what precisely occurred surrounding FTX, including SBF, Alameda, and all the various offshore holding companies that we are come to realize exists in this very complex tax structure that his father helped him create, who's a tax specialist. So, I mean, you have people right now like Mr. Jim Cramer, you might have heard of him, boldly claiming, and I quote, investors should cash out of crypto while they can, and many of which are jokingly stating this means a bottom call or a huge buy signal, which is funny. But in all seriousness, joking aside, this is a devastating moment in our industry. And I care about this industry, and I know you care about this industry. But I believe this will go down in the history books as a pivotal culminating event and what has been a truly unprecedented time for crypto the past 2 years, to be honest. I mean, from the epic and allegedly sabotaged downfall of the algorithmic stablecoin Terra Luna and its leader Do Kwon, which hurt the credibility of DeFi and crypto as a whole, to the last year's 2021 downfall of both Celsius and BlockFi when US securities regulators brought actions alleging offerings of unregistered securities. Now, it is evident, it is extremely apparent that with no clear legal regulatory framework in place in the United States, it has not only created extreme FUD, fear, uncertainty, and doubt, market volatility, but it also has factually harmed many innocent people that, seemingly giving fraudulent bad actors like SBF an avenue to evade liability or to hurt people. This is one major reason why we must begin to properly regulate the space with common sense legislation from our congressional House of Representatives and senators. Not talking about holding on to a bill for a few years and going back and forth or hiring a committee to advise. Write a damn bill. We need legislation and we need it yesterday. These types of events, unfortunately, in my opinion, will continue to happen if we don't push our elected officials to do their damn job and actually create some legislation for a framework for our industry that we desperately, desperately need. Far too many people have been financially harmed or exploited at this point publicly by bad actors to not see a real push for legislative action. Now, what makes this case interesting to me is this not only just is about retail investors being harmed, which we all know nobody cares about. Gary Gensler doesn't care about those people. The SEC doesn't care about those people. However, there are now high-profile A-list celebrities. There's institutions and VCs involved, such as, examples: Tom Brady, Gisele Bundchen, Mr. Wonderful Kevin O'Leary from Shark Tank, Visa MasterCard, the Miami Heat NBA franchise, and even Jason Bourne himself, Matt Damon, were all involved with FTX. That's just naming a few people. So the primary focus on this video as an attorney is I'm addressing the potential legal implications of one of these bad actors who's primarily responsible for our current crypto apocalypse, Mr. SBF. He went from the golden boy of crypto to public enemy number one, villain of the world, because of everything that's going down in the past couple days. Now, digging into the weeds here with my my legal analysis, not financial analysis, not legal advice. This is all my personal opinion. This does not form an attorney-client relationship with you whatsoever. Information and educational purposes only, goes without being said, but I'm going to state it multiple times. To dig into the weeds, SBF has most likely committed a series of variations of fraud, right? So you've probably heard the word fraud before. That's legal terminology for misrepresenting facts and circumstances in a malevolent manner for material gain, all right? So we will focus in this video on some of the more obvious and likely legal implications, which is why a potential prosecutor indictment on a single charge of wire fraud that we'll discuss later on is so relevant to this case. Now, keep in mind, this is a nuanced, complex scheme. This is not a simple set of facts, and we don't even have all the facts like I stated at the beginning of this video. So the causes of action, the charges that I'm going to be discussing as potential implications and potential legal issues are just really, to set the precedent here, just really the tip of the iceberg. This is basic stuff, mainly because I saw that there's a lot of people on crypto Twitter and online generally who seem to be confused or questioning or curious about this topic. I've seen a lot of misinformation, like people are saying things that are just not true, not just facts, like they're not legally true what they're stating. And I think this would be helpful for people, and it's something that I really love and research and I'm obsessed with, so I might as well share those thoughts with you guys. So with all that being said, there's most likely, okay, in my opinion, enough evidence to show more likely than not a probable cause that SBF has committed a crime and should be arrested by the appropriate authorities. From a legal perspective, in a case where there is supposedly blood money and government involvement, the cogs of the court will most likely move extra slowly because the wheels of justice grind slowly but very fine, as the saying goes. The government does not move fast. Anybody who has worked in the government knows this. I was in the military in a past life, so I understand this. The government is not efficient. They move slowly. So when we're talking about the SEC, my Ripple XRP people out there know this. The XRP army knows this. We talk about the Department of Justice. These are government bodies that are enforcing federal law, okay? They're not efficient. Like, I'm not even talking about allegations of corruption or collusion or anything of that nature. I'm just simply stating they are not fast. So people that have this unrealistic expectation about speed right now and resolution and like getting answers, let me just rein you back and remind you or inform you if you didn't know, the government's not going to move fast, especially with a case of this magnitude. Now, with that being said, because it has so much publicity and I personally believe there's going to be a lot of pressure. You're going to have people going to DC applying some serious pressure on these regulators and congressional members, and you're seeing it all over the media. That's not going away. So I think you're probably going to see an uptick in speed that's faster than normal, but don't be surprised that it's still slow. Bottom line. So let's start with the fact that there are two separate courts of law in the United States involved: civil and criminal. Okay, so criminal law deals with behavior that is or can be construed as an offense against the public, society, or the state. So even if the immediate victim is an individual. So examples: murder, assault, theft, drunken driving. Whereas civil law is dealing with behavior that constitutes an injury to an individual person or other private party, such as a corporation. So examples are defamation, the Johnny Depp case, libel and slander, right? Speaking and written, breach of contract, negligence resulting in someone's injury, or property damage. So criminal law and civil law differ with respect to how cases are initiated, who may bring charges or file suit, how cases are decided by a judge or a jury, what's called a bench trial or a jury trial, what kinds of punishment or penalty may be imposed, what standards of proof must be met, and what legal protections may be available to the defendant. In criminal cases, for example, only the federal or state government may initiate a case. Cases are almost always decided by a jury, and then punishment for a serious felony that would also consist of imprisonment, but may also include fines paid to the government. So to secure conviction, the prosecution must establish guilt, what is called beyond reasonable doubt. That is the burden of proof. And defendants are protected against conduct by the government, by police, or prosecutors that violate their constitutional rights, including the right against unreasonable searches and seizures, the Fourth Amendment, and the right against compelled self-incrimination. I plead the Fifth Amendment. Everybody knows that. So in civil cases, by contrast, cases are initiated, meaning lawsuits are filed by a private party, the plaintiff, and cases are usually decided by a judge, a bench trial, though certain significant cases may involve juries, right? Not unheard of. Punishment almost always consists of a monetary award of damages and never consists of imprisonment. We're not talking about liberties and rights here. To prevail, the plaintiff must establish the defendant's liability only according to the preponderance of the evidence, which is the burden of proof, a lower threshold compared to the criminals beyond a reasonable doubt. It's usually stated more likely than not is a way to think about that. Versus beyond a reasonable doubt, it's 95% sure. And defendants are not entitled to the same legal protection as are the criminally accused are. Importantly, because a single wrongful act or series of acts may constitute both a public offense and a private injury, it may give rise to both criminal and civil charges. Okay, so that should ring a bell, because in our present crypto case at hand, we have a series of potential wrongful acts that both constitute a public offense and a private injury. Therefore, what I'm trying to say here is expect civil lawsuits from customers and investors trying to recover what's left of FTX's assets, if any. Hate to say that, but that is what it is. And the Department of Justice, which are an agency of the federal government of prosecutors, they're now allegedly reported to be investigating this matter. Now, this raises the question of whether criminal charges will be filed against Mr. Bankman-Fried. So despite all the noise going on about this situation, and there is a ton of noise and distraction, let's boil this down and discuss two major potential legal obstacles to any criminal conviction in this case, with the understanding, in my opinion, and a few others, that prosecutors can most likely overcome these two legal issues that we're facing with this case. All right, so legal issue number one is jurisdiction. I actually was in that Twitter space that everybody's on. I don't know the name of it. If you're in crypto Twitter, you know what I'm talking about. The one that is discussing this. And at one point, on Saturday, I was graciously allowed to, because I'm an attorney, and the group, and the presenter asked if there was any legal professionals in there, and I DM'd them, and I spoke a little bit nervously in front of all those 30,000 plus people in there. And I stated this actual issue is jurisdiction, right? So legal issue number one, jurisdiction. What is that? So why does it matter? FTX, everybody knows they're an offshore business with its headquarters operating in the Bahamas, not the United States. So legally speaking, we have what is both called personal jurisdiction and subject matter jurisdiction in the United States. Personal jurisdiction is when a court has jurisdiction over a person that lives in a certain geographic area or has such, quote, Supreme Court minimum contacts with the state. Subject matter jurisdiction refers to the limitations on the types of cases a court can hear. Certain courts can only hear certain disputes. For example, bankruptcy courts and federal court can only adjudicate U.S. bankruptcy proceedings. Now, with that being said, the criminal division of the U.S. Department of Justice, the DOJ, is what we'll call it, and the enforcement division of the United States Securities and Exchange Commission, everybody knows this big bad boy SEC, they do have legal authority. I repeat, they do have legal authority to prosecute certain bad actors operating overseas, specifically under the federal law called the U.S. Foreign Corrupt Practices Act, also known as the FCPA. So for simplicity and time's sake, we will discuss only the DOJ and individual defendants as written in the FCPA. There are other sections outlining specifics on the SEC and corporations, but we're talking about the DOJ here, Department of Justice, and an individual defendant, SBF, because that seems to be a big question in the community, is his criminal liability potential. So the Department of Justice is pretty damn good at finding what's called a nexus, like a link overseas with overseas defendants to American shores. So for context, according to Randall Eliason, who is a former prosecutor who now teaches at George Washington University School of Law, essentially his position is that it would likely be easy for prosecutors to find a nexus in the FTX case between United States banks, emails, stateside meetings, tweets, emphasizing the tweets. He's had a few damning tweets that I think have since been deleted. If you know what those tweets are, go ahead and put them in the comments below, because I don't have them all saved and I'd love to dig further into that evidence. And then other just basic interactions. So to get in the weeds of that statement, because that's what I'm here for. The principles of federal prosecution set forth in chapters 9 through 27 of the Justice Manual provide guidance for the Department of Justice prosecutors regarding initiating or declining prosecution, selecting charges, and plea bargaining. So, the principles of federal prosecution provide that prosecutors should recommend or commence federal prosecution if the potential defendant's conduct constitutes a federal offense and the admissible evidence will probably be sufficient to obtain and sustain a conviction, unless there's three factors that are unless. So unless these things are at play. One, no substantial federal interest would be served by prosecution. Okay, obviously not the case. Two, the person is subject to effective prosecution in another jurisdiction. There's too much, I think there's too many implications with the United States and businesses, investors, retail. So in my opinion, that's not a non-issue. And then three, an adequate non-criminal alternative to prosecution exists. Are monetary fines adequate? That's a question of fact, but I personally believe they're not. I think with the alleged malevolent behavior and magnitude of it and massive scam or fraud that was perpetuated, I don't think that civil court alone would be an adequate remedy, in my opinion. Now, in assessing the existence of a substantial federal interest, the prosecutor is advised to, quote, weigh all relevant considerations, including the nature and seriousness of the offense. This is extreme serious, and the gravity and nature of this offense is pretty high, I would argue. The deterrent effect of prosecution is also high, because we don't want people like this ever doing this again in our industry, or in any industry, really. The person's culpability and connection with the offense, I'd argue this is high, because SBF seems intimately involved with literally this entire schematic. The person's history with respect to criminal activity, not much there. The person's willingness to cooperate in the investigation or prosecution of others. That one's interesting, because I know he has high-level attorneys and advisors and political ties doing everything they can to protect him at this point. Protect the king, let the peasants follow, or let the peasants fall under you. That remains to be seen. And then the probable sentence or other consequences if the person is convicted. All right, so the principles of federal prosecution also set out the considerations to be weighed when decide whether to enter in a plea agreement, which is like a settlement in criminal court with an individual defendant. So it includes the nature and seriousness of the offense and the person's willingness to cooperate, as well as the desirability of prompt and certain disposition of the case and the expense of trial and appeal. Now, speculation, personal opinion, if we get to this point and we're at looking at the principles of federal prosecution and we're weighing considerations about a plea agreement, and he's, been detained, arrested, he has counsel, we are knee deep in court. I don't see the plea. I mean, it'll probably be negotiated for sure, but I see him serving time. That's speculation, but that's my it's my speculation and opinion of the matter. All right, so that's legal issue number one, jurisdiction. I hope that helped you guys understand that yes, it's an offshore business. However, the United States, through Department of Justice and SEC under the FCPA, has legal authority to extradite his ass and bring him to the U.S. and put him through our criminal court proceedings. Now, legal issue numero dos, criminal intent. Okay, we're going to talk about the legal issue of criminal intent being a major implication here with this case, also known as what's called in Latin and criminal lawyer nerd language, mens rea, for those who care. So because the standard of proof, as I told you guys earlier, is much higher in criminal courts, the intent must be proven beyond a reasonable doubt, not a mere preponderance of the evidence. So specifically, any criminal conviction for SBF will turn on whether he was intentionally deceiving investors and not simply negligent or incompetent, right? It has to be a higher threshold than that. So the malicious, deceptive intent to fraudulently induce investors is what we're going to be looking at here in this case with SBF. This is proven with facts by the prosecution, such as, if there's some smoking gun type of communication or demonstrating a pattern of behavior. I think that one will be very evident. That points to fraudulent intent. And there are many charges called counts in federal criminal proceedings which could be brought against Mr. Bankman-Fried under both the FCPA and the federal criminal wire fraud statute, section 1343. Excuse me. So wire fraud, for those of you who don't know, is important. And it's a term that describes a variety of fraud committed with the aid of electronic tools, which is obviously very relevant to a cryptocurrency case utilizing an online centralized exchange to transfer money and assets. So better stated in some case law. I'm going to give you guys some case law. U.S. v. Profit in the Eighth Circuit Court of Appeals. They had a ruling that laid out the four essential elements of the crime of wire fraud that I thought were stated very eloquently. One, that the defendant voluntarily and intentionally devised or participated in a scheme to defraud another out of money. I think that is evident. Two, that the defendant did so with the intent to defraud. Again, that mens rea. Three, that it was reasonably foreseeable that interstate wire communications would be used. Obviously, yes. With cryptocurrency, centralized exchanges, that is beyond reasonably foreseeable that interstate wire communications would be used. And four, that interstate wire communications were in fact used. Clear as night and day. Yes, absolutely. So based on the facts we have seen revealed at this time, right? I say facts lightly because we don't know all of the facts, or we have not confirmed everything. But based on the information that we have now, let's say that regarding SBF's operations, his actions, his tweets, his personal behavior, patterns of behavior, his meetings, public statements he's made, etc., there is a strong argument that all the elements are in place for the Justice Department prosecutors to bring a case under Section 1343 for wire fraud. The statute, fun fact here for you guys, the statute carries a maximum penalty of 20 years in prison. So when you hear BitBoy going ham on SBF, which, hey, shout out to BitBoy. If I somehow reach you, that would be amazing. Big fan. Big fan to you, Ben. He's constantly mentioned the wire fraud potential consequences of this whole situation. 20 years in prison is what we're looking at for that. That one count alone, by itself, just one, 20 years, okay? I'm just talking about like most likely legal implications right now. Not all the facts are fleshed out, and we can't determine exactly what's going to happen until we know what actually happened. So please keep in mind that as of the time of this recording of this video, which is my first video, by the way, and I hope to do many more of these, SBF is not currently charged with anything and would be presumed innocent until proven guilty in a court of law after being given his due process rights afforded under the U.S. Constitution. I am a huge advocate for that, for due process, and for everyone to have equal access to and enforcement of an applicability of the United States constitutional rights to each citizen of the United States. So that's very important that we remember that. And also, it should be noted that if the DOJ would potentially have to go after, they would have to potentially go after other FTX executives, okay? So all those other people in the orgies, like joking around, whatever's, the 10 people in his international company that were not board executives, or just executives, the Department of Justice would need to locate and what's called extradite them back to the United States, like arrest them overseas, bring them back, and put them in through the U.S. court process, okay? I've seen unconfirmed, emphasis on unconfirmed reports written in a few articles that a few of these key FTX executives are hiding in Hong Kong while SBF allegedly remains in the Bahamas. If you have any information on that, send it to me on Twitter or put it in the comments below and let's talk about it, because I want to hear about it. Because I'm going to continue to cover this case and I'm going to continue to give my insights, because I not only find it fascinating, but I am got a fire lit up under my ass about this, because I'm tired of seeing our industry get wrecked. It was like the wrecked after wrecked after wrecked. Like, I want to see some legislation. Let's get the community involved. Let's push for legislation as a community. Let's see that, there's traders involved, there's accountants involved, there's attorneys involved, where the people of the United States and in the world are pushing for clear frameworks. I think that's a good thing, and we should all be doing that. So hopefully this video sheds some light for my viewers. I have 0 viewers, but whoever did view this, on what potential legal implications are surrounding this ongoing cryptocurrency case. I'm an attorney and I cover digital asset and crypto industry legal analysis. I've been a cryptocurrency investor myself personally since 2019, a contract nerd, economics junkie, blockchain lover, and an advocate for the democratization of finance. Absolutely. If you found just a fractional reserve of value in my video today, please show me your support with a thumbs up and subscribe to my channel for more crypto legal analysis. Reminder, all content is my personal opinion. It is not legal advice. This is for educational and informational purposes only. Always do your own due diligence when making financial decisions, okay? And hire your own attorney to receive legal advice or legal services. I love you all. Stay blessed and